Well, hello, everyone. Friends, welcome. My name is Carolyn Lee, principal and founder of Carolyn Lee PLLC, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. I feel like it's been a while since we've convened, so I'm really excited to talk about regional center audits. They are coming again under the EB-5 Reform and Integrity Act. I remember before our run up to the passage of the RIA, which took a few years longer than we all anticipated, then Secretary of DHS Jay Johnson wrote a letter to then chairman of the Judiciary Committee on the Senate side, Senator Grassley, asking, it felt like begging for statutory authority to do exactly this, to increase oversight over the regional center program. And at the end of it, we have 100 pages of legislation, the EB-5 Reform and Integrity Act, that did just that, give USCIS authority for increased oversight and administration of the regional center program. So we're going to look at an important part of that, regional center audits. USCIS made the announcement on on April 9th of this year that it would start conducting these audits. So that's what we're going to talk about today. And these are my initial reactions. This is all very, very new. And we will no doubt have lots to talk about in the months and years to come. So I'm going to start by sharing a presentation, which I rarely do, but it felt like the right thing to do on this occasion. Okay, so they're coming, what we know and what we don't know, and the questions that we have. To start, let's go with a bit of a disclaimer. This isn't advice and doesn't create an attorney-client relationship. This is informational and promotional and attorney advertising. Topics. Let's just briefly run through who I am and all of that. It's on my website. We might not even cover it, but it's here and it's on the slides. We're really going to talk about audits, regional center audits. All right, a bit about myself. Done a lot in the EB-5 space, okay? I've served as chair, co-chair, vice chair of American Immigration Lawyers National EB-5 Committee for a number of years. I serve as Invest in USA, IIUSA's legislative council, and was a part of the dream team that led to the passage of the EB-5 Reform and Integrity Act, affectionately known as RIA or the RIA. I currently serve as co-chair of IIUSA's Public Policy Committee. On the representation side, that's all my advocacy experience. On the representation side, I've had the great privilege and fun of representing U.S. project clients, regional centers all over the country, who have successfully raised well over $2.5 billion in EB-5 capital. And on the investor side, again, so privileged and honored to have represented thousands of EB-5 investors and families through all stages of the EB-5 immigration process. All right, that out of the way, let's jump into this. Okay, so April 9th, USCIS announces, hey, we are going to start auditing regional centers as we are required to do under the RIA. And this is the language that's in the announcement. And it is linked also on this presentation that you will get. Under the new provisions of Section 203B5E7, added by the EB-5 Reform and Integrity Act of 2022, RIA, to the Immigration and Nationality Act, INA, we must audit each designated regional center at least once every 5 years to enhance the integrity of the EB-5 program by helping us verify information in regional center applications and annual certifications, as well as associated investor petitions. Okay, sounds pretty plain. And it also announced in the same missive that USCIS will start generally using generally accepted government account auditing standards, or GAGAs, for regional center audits. Now, this is brand new to us all in the EB-5 sphere, right? We've never had GAGAs in our lives. And so we are going to be really looking into what is GAGAs and how does it pertain to regional center operations and audits, right? And in the same announcement, also the service said, we created a new page dedicated to regional center audits, which everyone should visit. It has quite a bit of information there, revealing, and also a very lengthy Q&A there as well. Okay, so let's kind of unpack this a little bit. As I like to do, let's start with the fundamentals, the law. And this is the law that is cited, and this is what gives USCIS authority to conduct these audits. And it's in section 203B5E7. Regional, and I'm going to read it. Regional record keeping and audits. Roman 1, record keeping. Each regional center must make and preserve during the 5-year period beginning on the last day of the federal fiscal year in which any transactions occurred, books, ledgers, records, and other documentation from the regional center, new commercial enterprise, or job creating entity used to support item AA, any claims, evidence, or certifications contained in the regional center's annual statements under subparagraph G. So this is the I-956G, and item BB, associated petitions by aliens. These are investor petitions seeking classification under this section or removal of conditions under section 1186B of this title. So what does that mean? Investor petitions, and now with the new filing process, how does this tie into investors? Well, this is your F. This is the regional center's 956F filings that are associated with each investor's petition in that new commercial enterprise described in the F. And for the 829s, the removal conditions, it's the portion of the 829 petition that pertains to job creation. Roman 2, audits. The secretary shall audit each regional center not less frequently than every 5 years, once every 5 years. Each such audit shall include a review of any documentation required to be maintained under subclause 1, which we just read, for the preceding 5 years, and a review of the flow of alien investor capital into any capital investment project. So this is important because we have the specific items of record keeping in clause 1, subclause 1. And this, we have an added element, a third element right here, which is the flow of funds. Okay. To the extent multiple regional centers are located in a single site, the secretary may audit multiple regional centers in a single site, which would be great. And then the consequences. Termination. If the secretary shall terminate the designation of a regional center that fails to consent to an audit under subclause 2 or deliberately attempts to impede such an audit. So this is pretty specific. The regional center has to fail to consent or deliberately attempt to impede an audit. Doing either of those would trigger a termination. So that's what the statute says in terms of the scope of an audit. Here is the list of audit team tasks that are published in that dedicated webpage in terms of what the services audit team would do. Reviewing applications, certifications, and associated records, reviewing public records and information on the regional center, very general, rather vague. Verifying the information, including supporting documentation submitted with applications and in annual statements. How? Conducting in-person audits through a site visit when applicable. This is worthy of a bit of a pause because there's a question as to whether or not an audit is the equivalent to a site visit, which is also in the RIA. And we'll talk about this later, but site visits are arguably not the same thing as compliance, as audits. Site visits relate to job creation and to checking on entities relevant to job creation. So how would that tie in with a regional center audit? Another interesting thing to note about site visits, I think it might be no accident that this announcement was made in April, roughly 2 years, a little over 2 years after the passage of the RIA on March 15, 2022, because under the RIA, site visits could not begin until 2 years after the passage of the RIA, and we've cleared that threshold now. So now the service can begin conducting site visits under the RIA. So there might be some conflation happening here. The tasks will also include assessing the effectiveness of internal controls related to the regional center's administration, oversight, and management functions. Assessing the effectiveness. So somebody might actually make some judgments about the effectiveness of the internal controls related to the regional center's administration, oversight, and management functions. Now, you might be asking yourself, as I did, how does this tie to the record keeping along those two dimensions, those two items relating to the 956G regional center certification and investor petitions and investor flow of funds? The third element brought in by subclause 2. Reviewing and analyzing financial documentation. Now, I think this is a point that we as an industry would be discussing and hopefully in dialogue with the agency, because clearly this is where GAGAS comes in. Now, financial documentation is not specifically in those two elements and in the investor flow funds expressly, but query whether that is in the concept of an audit, which is the term used in the RIA. Reviewing the flow of investor capital into capital investment projects, that is in the RIA. Interviewing personnel to confirm the validity of the information provided with applications and annual certifications. Now, on its face, this could sound pretty innocuous, but we don't have any standards here on how these interviews would be conducted, who would be inducted. Could it be a temp? Could it be somebody who doesn't know anything about the regional center operations? Okay, let's move on. Also in the dedicated audits page, we have this process, this flow of what one could expect in the course of an audit. And I do applaud this, sharing of what the process would look like. There's a start of the audit process, and there would be a notification letter, that's good, to regional centers, and request for information. Now, we don't yet have any visibility into what this request for information would ask for or look like. Would it be uniform? Would it have some specific elements? Would it be a hybrid of the two? We would need to know, I would think. And then entrance conference with the regional center. So presumably this is some kind of a conversation part of the audit process. Receive and review regional center request for information response. So it's contemplating, it appears, a written dialogue where that response is reviewed. And then audit field work and site visit decision. Now, this, or I'm not quite sure how to interpret this. This is clearly the next step, audit field work, site visit decision, but there's also audit field work, in-person, virtual site visit. So not clear what the relationship is there. Maybe somebody, it's more obvious as somebody here. But there's a potential field office / site visit. At the end of which is the exit conference with the regional center. It looks like another dialogue point with the regional center. And then there's a closeout memo, final audit results, and the end of the audit process. We don't know what this process is. There's a written record, there's a closeout memo, and then there are the results. Very little doubt that these items would be made a part of the regional center record. Would the regional center have access to that record? Because this information from experience could pop up in some other context, perhaps in the course of an investor's 829 adjudication, many years down the road. So I think it would be very important for folks to know, well, what are the contents of this? And will this be shared with the regional center? Because for certain, it will be a part of the regional center record. The consequences, let's pause a bit on that. If a regional center does not consent to an audit or deliberately attempts to impede an audit, we, USCIS, will close the audit, and the audit results will show that the regional center did not consent to the audit or deliberately attempted to impede the audit. We, USCIS, will then terminate the regional center's designation as it is authorized to do under the RIA. So because the consequences are rather dire, and it is authorized, termination of the regional center, I think it is very important to get clarity on the scope of what this means. Does not consent or deliberately attempts to impede. What if the regional center challenges the contents of a request or provides answers that may raise questions or challenge some aspect of the interview process or the questions or the way that the responses appear to be interpreted? Or maybe later, if the results of the audit are shared with the regional center, which I again believe strongly that they should be, would any of those or other actions be construed as not consenting to an audit or deliberately attempting or a deliberate attempt to impede an audit? I think this is very important. Audit results. The outcome of an audit will not by itself result in direct consequences to the regional center or to any entity or petitioner associated with the regional center. However, we, USCIS, may use our audit findings to evaluate a regional center's continuing eligibility to remain designated, as well as compliance of associated applications, petitions, or other filings. So, in other words, this information can be tucked away and potentially used to the prejudice of a regional center. When we think about this, I think we kind of might have two minds about it, right? One is absolutely, yes, we want, we wanted more oversight brought into the program. We embrace it. And yes, if there is anything that, is troubling, that should be actionable. On the other hand, when there are pockets or invitations of discretion without standards, that it raises alarm as well, because that means then there's an opportunity for a regional center that is operating consistently with the law, completely above board, consistent with the spirit of the RIA, etc., being found in an audit context by an examiner to somehow not be conducting itself in accordance with some of these standards that are set out here that are not well defined and not keyed directly to the statute, and suffering some negative consequence as a result. Now, that's what we don't want. And I do see a question there, and I will get to that near the end of the presentation part. And here we go. General use of these GAGA standards does not remove the adjudication officer's discretion in considering the results of an audit in connection with making adjudicatory decisions. Again, yes, judgment is a part of any human process, but we need standards, boundaries, and we don't have those yet. Okay, so what we don't know and questions. Some of these I touched on already. What will be the content of the request for information? Will it be uniform, across the board, tailored, some combination? Will we receive public advance notice of the contents? I would say we should. Should audits and site visits be completely separate? I think that is a conversation that we within the EB-5 industry ought to have. Is GAGAS the appropriate standard for regional center audits? I think this is a question. We will all be studying what this really means. I started my study of it. It appears to be, and I welcome correction and amplification. It appears to be standards used when the federal government audits those recipients of federal funds, including agencies of the government. So that on its face sounds perfectly appropriate. The question is that the appropriate standard to audit regional centers? We need to look at this. Will regional centers have access to the record created by the audit? I think that's important. Is there a venue to challenge the scope or results of an audit? I think that is also, that's tied to the first. We've got to know what the record says to be able to correct and to challenge. And what is the appropriate venue there? What is the venue? Okay, great. At this point, I can take some questions. So I'll stop sharing and take the first question. Is the regional center or the investment target entity responsible for returning the capital invested? Are there any laws that stipulates the investment target entity to pay back timely after? Okay, so that's exceeding the scope of what we're talking about today. But thank you for that. All right. And I really meant this to be kind of an introductory primer on what's been said and the questions that what's out there raise. We will continue to have this conversation. We must. There's one more question. Could audits influence or affect EB-5 applications for regional center? Yeah, yes, I think so. And I think the authority for that could be tied directly to the language in the statute. Okay. So yeah, this is of great importance and interest to everyone in the ecosystem. Do you think source of funds documentation will be included in the documents requested for RC to submit? I think that there is some interpretation here in terms of, let's just go back. Okay. All right, let's go back. Let's go back to the language. So we're talking about potentially two places in your question, I would say. Associated petitions, record keeping, regional center obligation for record keeping, associated petitions by aliens seeking classification under this section or removal of conditions under section 1186B of this title. So the regional center is required to make and preserve records used to support associated investor petitions. So I think a reasonable interpretation of this, as I referenced earlier, would be, for example, the F, 956F, record used to support an investor's I-526E petition. Now, would that go to investor source of funds? To what degree would the regional center want to maintain records of investor petitions beyond the F itself, which it is filing? These are questions that at this point, different regional centers have different approaches to. And perhaps with time, there will be an emergence of a standard or best practices. Right now, this language does not compel or strongly suggest that there is one strong reading, is my view. All right. Okay. Great. Well, thank you everybody for joining me. And more to come. Have a great rest of the day, evening, morning, and we will be in conversation soon. Goodbye.